Appeal, Campbell and Gordon.
Lord Hodge will Lord Carnwath will deliver the judgment.
Mr Campbell was employed as an apprentice joiner by a company whose sole director was Mr Gordon. Mr Campbell suffered an injury whilst working with an electric saw. The company's employer's liability policy excluded claims arising from the use of woodworking machinery powered by electricity, and thus excluded any claim arising out of this accident. This was a breach of the company's obligations and an offence under the Employers' Liability Compulsory Insurance Act 1969. However, the company is in administration, and Mr Campbell now seeks to recover damages from Mr Gordon personally. Section 5 imposes criminal liability on a director whose neglect facilitated the company's offence, but says nothing about civil liability. The claim was upheld by the Lord Ordinary, but dismissed by a majority of the Inner House. The Supreme Court dismisses Mr Campbell's appeal by a majority. The leading judgment is given by me with the agreement of Lord Mance and Lord Reid. Lord Toulson and Lady Hale would have allowed the appeal. The majority acknowledges the general principle that where a statute imposes an obligation for the protection of a particular class of individuals, particularly in the context of employment, civil liability is normally implied. However, this does not mean that a person can be made indirectly liable for breach of an obligation imposed by statute on someone else, even a company controlled by him. In Section 5, Parliament has pierced the corporate veil to the extent only of imposing a specific and closely defined criminal penalty on a director linked to the criminal liability of the company. There is no basis in authority for extending that so as to impose personal civil liability on an individual director. In the minority's view, by contrast, the criminal liability placed on the director by Section 5 carries with it a legal obligation not to permit the company to be without the required insurance. That, they say, is sufficient to bring it within the long-established principle that breaches of legislation for the protection of employees are actionable at common law. If the legislation is silent, they say, the judge's role is to fill the gaps.
Court is now adjourned.